I pulled into the guest parking lot of Riverside Meadows condominiums at 8 in the morning, exhausted from an overnight shift at the hospital where I work as an emergency room physician. My name is Wade Garrison, and I own 3 units in this Phoenix, Arizona complex. One unit is my primary residence, and the other 2 I rent out to cover my mortgage and generate some extra income. After a 16-hour shift dealing with everything from cardiac arrests to broken bones, all I wanted was to collapse into bed. The main parking structure was undergoing repairs that week, with half the resident spots blocked off for resurfacing. Management had sent out an email 3 days earlier saying residents could temporarily use guest parking until the work was completed. I had the email saved on my phone, having read it twice to make sure I understood the policy correctly. Guest parking sat at the front of the complex, closest to my building, which made the temporary arrangement actually more convenient than my usual spot. I parked my black Tesla Model 3 in a guest space, grabbed my backpack, and headed toward my unit. The Arizona sun was already beating down, promising another scorching day. I noticed a woman standing near the community center building, watching me with her arms crossed. She wore a visor, yoga pants, and had that particular stance that screamed trouble. I had seen her around before, usually complaining about something at board meetings. Her name was Brenda, and she served as the HOA vice president, though she acted like she ran the entire complex. I ignored her stare and went inside, showered quickly, and fell into bed. Sleep came fast. 3 hours later, my phone started ringing. I groaned, reaching for it blindly. The number was unfamiliar, but I answered anyway, thinking it might be the hospital. "Is this Wade Garrison?" A gruff male voice asked. "Speaking," I mumbled, still half asleep. "This is Jim from Valley Boot Removal Services. Your vehicle has been booted in the parking lot at Riverside Meadows. You need to pay $250 for removal." I sat up straight, suddenly wide awake. "What?" "My car was booted." "Yes, sir. Black Tesla, license plate ending in 732. You were parked in guest parking without authorization." "I have authorization. Management sent an email saying residents could use guest parking during the repairs." "Not according to the HOA representative who called us. She said you were parking illegally. You need to pay the fee to get the boot removed." My jaw clenched. I knew exactly who had called them. "I will deal with this in person. Do not remove the boot yet." I hung up, threw on clothes, and stormed back outside. Sure enough, my Tesla had a bright yellow boot clamped onto the front driver's side wheel. Standing next to it was Brenda, talking on her phone. When she saw me approaching, she ended her call with a satisfied smile. "Good morning, Wade. I see you found your vehicle. Why did you have my car booted?" I kept my voice level, though anger simmered beneath the surface. "Guest parking is for guests only. Residents are not permitted to park here. Management sent an email saying we could use these spots during the parking structure repairs. I have it right here." I pulled out my phone and showed her the email from the property management company. Brenda barely glanced at it. That email was sent without HOA board approval. "The board has override authority on all parking matters according to our CC and RTCS. I am enforcing proper parking regulations. You are enforcing your personal vendetta. This is the 3rd time you have targeted me specifically." Her smile widened. "I have no idea what you mean. If you feel you have been treated unfairly, you can bring it up at the next board meeting. In the meantime, you need to pay the boot removal fee. I am not paying a dime for an illegal boot. Then your car will sit here until you do." She turned and walked away, her visor bobbing with each step. I called the property management company immediately. A woman named Lisa answered, and I explained the situation. She sighed heavily when I mentioned Brenda's name. "Mr. Garrison, I am so sorry. Brenda has been causing issues all week. She keeps contradicting our management decisions." Yes, that email was legitimate, and yes, you absolutely have permission to park in guest parking right now. She had no authority to call a boot company. "Can you call them and get this removed?" "I will try, but she used her personal contract with Valley Boot Removal. They might not listen to us." "Let me make some calls and get back to you." 20 minutes later, Lisa called back with bad news. The boot company refused to remove it without payment, claiming they had a contract with the HOA that superseded management authority. According to them, any board member could authorize a boot, and they would not reverse it without either payment or a court order. I stood in the parking lot, staring at my immobilized car, and made a decision. I was not going to let Brenda get away with this. I took photographs from every angle, capturing the boot, the parking space, the guest parking signs, and the nearby posted rules. Then I photographed the email from management on my phone screen. I documented everything. Next, I called my attorney, Marcus Chen, who had helped me with the purchase of my rental units. His office was in downtown Phoenix, and he agreed to see me that afternoon. "Bring all your documentation," Marcus said. "This sounds like harassment and possibly an illegal boot, depending on your HOA's governing documents." I took an Uber to his office, a sleek building with floor-to-ceiling windows overlooking the city. Marcus met me in a conference room, his tie loosened after what I assumed had been a long morning. He listened carefully as I explained the situation, occasionally taking notes. "How long have you owned units in this complex?" he asked. 4 years. I bought the first unit when I finished my residency, then purchased the other 2 over the following 18 months as investment properties. "And this Brenda person, how long has she been targeting you?" "It started about 6 months ago when I raised concerns at a board meeting about how they were spending reserve funds. The complex needed new roofing, but they wanted to spend $60,000 on decorative landscaping instead. I pointed out that the roofing was a critical infrastructure need and should take priority. Several other owners agreed with me, and the motion for the landscaping failed." Marcus nodded. "So she has a personal grudge?" "Absolutely. 2 months ago, she tried to fine me for leaving my trash bins visible from the street. The thing is, everyone's bins are visible on trash day because that is when collection happens. She only cited me. Then last month, she claimed one of my tenants was playing loud music and threatened fines, but my tenant works night shifts and sleeps during the day. The complaint was completely fabricated." "Did you document those incidents?" "I have all the emails and notices she sent." "Good. Here is what we are going to do. First, I will send a demand letter to the HOA and to Valley Boot Removal Services. The letter will state that the boot was unauthorized, that you had explicit permission from property management to park there, and that both parties need to remove the boot immediately and refund any fees if you choose to pay them. Second, if they refuse, we file a lawsuit. Against both of them." "Against both. The HOA for harassment and violating their own rules, and the boot company for participating in what amounts to an illegal immobilization of your vehicle. We will also include claims for your damages, including your time, legal fees, and emotional distress. How strong is the case?" Marcus leaned back in his chair. "Very strong. Arizona law is pretty clear about this stuff. HOAs have to follow their own governing documents, and they cannot enforce rules arbitrarily or discriminatorily. You have written permission from the management company, which the HOA hired to handle day-to-day operations. The board cannot just override that without following proper procedures. As for the boot company, they have a duty to verify that a boot request is legitimate before immobilizing someone's property. What are the chances they just remove it after getting the demand letter? 50-50. Some people back down immediately when they realize they screwed up. Others double down and make it worse for themselves. Given what you have told me about Brenda, I would bet on the latter. Marcus drafted the demand letter that afternoon while I waited. It was 3 pages of dense legal language that essentially said, "You messed up, fix it now, or face serious legal consequences." He sent it via email and certified mail to both the HOA's registered agent and to Valley Boot Removal Services business address. I paid for an Uber back to the complex. The boot was still on my car, exactly where I had left it. I took more photographs, this time with timestamps, then went back to my unit. I was too angry to sleep, so I spent the afternoon reviewing my HOA's CC and Articus, bylaws and rules and regulations. These were the governing documents that dictated what the HOA could and could not do. I found several relevant sections. First, the management company had explicit authority over day-to-day operations, including temporary parking arrangements. Second, any board enforcement action had to include written notice to the owner with an opportunity to respond before penalties were imposed. Third, the board could not act arbitrarily or selectively enforce rules against specific owners. Brenda had violated all 3 provisions. The next morning, I received an email from Brenda's personal email address, not the official HOA account. It read, "Dear Mr. Garrison, your vehicle remains in violation of parking rules. The boot will remain until payment is made. Additionally, you are now being fined $50 per day for each day the vehicle remains in an unauthorized space. Please remit payment promptly to avoid further penalties." I forwarded the email to Marcus immediately. He called me 5 minutes later. "She is insane," he said. "She is now adding daily fines on top of the boot fee. This just made our case even stronger. Do not respond to her. Let me handle all communication from here on out." What happens next? We wait to see if they respond to the demand letter. If they do not respond within 48 hours, we file the lawsuit. In the meantime, I am going to draft a motion for emergency injunctive relief. We will ask the court to order the boot removed immediately while the case proceeds. How long does that take? We can usually get an emergency hearing within a few days. I will mark it as urgent since your vehicle is being held hostage. That afternoon, Valley Boot Removal Services responded to the demand letter. Their attorney sent a terse email stating that they were acting under a valid contract with the HOA, that they had received authorization from a board member, and that they would not remove the boot without payment or a court order. They claimed they had no liability because they were following the terms of their contract. The HOA's response came the following morning. It was not from an attorney but from Brenda herself, writing as HOA vice president. Her email claimed that the board had emergency authority to override management decisions related to parking, that I was violating community rules, and that the boot and fines were appropriate enforcement measures. She cited several sections of the CC and Articus, but when I looked them up, none of them actually said what she claimed they said. Marcus filed the lawsuit that afternoon in Maricopa County Superior Court. The complaint named both the Riverside Meadows Homeowners Association and Valley Boot Removal Services as defendants. We sued for declaratory relief, injunctive relief, breach of contract, harassment, intentional infliction of emotional distress, and violation of Arizona's consumer fraud statutes. We asked for compensatory damages, punitive damages, and attorney's fees. The filing fee was $350, which I paid by credit card at the courthouse. Marcus also filed the emergency motion for injunctive relief, requesting a hearing as soon as possible. The court scheduled the emergency hearing for 3 days later, on a Thursday morning. Both defendants were served with the complaint and the motion. I continued taking Ubers to and from work, documenting each expense for our damages claim. On Wednesday evening, Brenda showed up at my door. I answered with my phone in my hand, recording audio. "Wade, we need to talk about this lawsuit," she said, trying to sound reasonable. "My attorney has advised me not to speak with you directly. All communication needs to go through him. This is ridiculous. You are suing the HOA over a parking dispute. Do you know how much this is going to cost the community? You are the one who created this situation. You had my car illegally booted even though I had permission to park there. The board has the authority to manage parking. No, you do not have the authority to act arbitrarily and target specific residents. You have been harassing me for months and I have had enough." Her face flushed red. "Harassment. I am enforcing the rules, selectively enforcing them against me while ignoring everyone else. That is called discrimination. You think you are so smart because you own 3 units. You do not get special treatment. I am not asking for special treatment. I am asking to be treated the same as everyone else, but you cannot do that because you are on a power trip." She stepped closer, her voice rising. "You are going to regret this lawsuit. The board is going to fight this, and when we win, you are going to pay our legal fees. Get off my property. This is common area. I have every right to be here. This is my front door, which is my exclusive property. Leave now or I am calling the police." She glared at me for a long moment, then turned and stomped away. I saved the audio recording and emailed it to Marcus. He replied within minutes. "Perfect. She just demonstrated the harassment. This helps our case significantly." Thursday morning arrived. I wore a suit and met Marcus at the courthouse at 8:30. The hearing was scheduled for 9. We went through security and found the assigned courtroom on the 3rd floor. It was a small courtroom, not one of the big ones used for trials. The judge's bench sat elevated at the front, with tables for the parties facing it. Valley Boot Removal Services sent their attorney, a man in his 50s named Gerald Peterson, who looked bored. The HOA was represented by Brenda herself, who had apparently convinced the rest of the board that they did not need to hire an attorney for this hearing. The judge, Honorable Diana Martinez, took the bench at exactly 9. She was a no-nonsense judge with a reputation for efficiency. She reviewed the papers quickly, then looked up at us. "This is an emergency motion for injunctive relief. Mr. Chen, you represent the plaintiff." Marcus stood. "Yes, Your Honor. Wade Garrison is my client. Mr. Garrison claims his vehicle was illegally booted in guest parking at his condominium complex. He says he had permission from property management to park there during scheduled repairs. The defendants refused to remove the boot without payment of $250. Is that accurate?" "Yes, Your Honor. We have submitted the email from management authorizing residents to use guest parking during the repairs. The HOA Vice President, Miss Brenda Zimmerman, called the boot company without authority and in violation of the HOA's own governing documents." Judge Martinez turned to Gerald Peterson. "Mr. Peterson, you represent the boot company?" "Yes, Your Honor. Valley Boot Removal Services has a contract with the HOA to provide boot services when called. We received a call from Miss Zimmerman, who identified herself as a board member and requested the boot. We followed our standard procedures. Did you verify that she had authority to make that request? Our contract states that any board member can authorize a boot. She is the vice president." Did you ask to see any documentation showing that the vehicle was actually parked illegally? Peterson hesitated. No, Your Honor. We rely on the HOA's representation that a vehicle is in violation. So you just take their word for it without any verification. That is standard practice in our industry. Judge Martinez did not look impressed. She turned to Brenda. Miss Zimmerman, are you representing the HOA? Brenda stood up. She had dressed professionally in a blazer and slacks, trying to look official. Yes, Your Honor. I am the Vice President of the Riverside Meadows HOA. Where is the HOA's attorney? We do not have one. This is a frivolous lawsuit, and we did not think it was necessary to spend the association's money on legal fees. This is a lawsuit seeking injunctive relief and damages potentially in the tens of thousands of dollars, and you thought it was frivolous? Yes, Your Honor. Mr. Garrison was parked illegally, and we enforced the rules. Did you read his complaint? He submitted an email from the property management company giving residents permission to park in guest parking during repairs. Do you dispute the authenticity of that email? Brenda shifted uncomfortably. The email was sent without board approval. Does the property management company have authority to make day-to-day operational decisions? Yes, but major policy changes need board approval. Is a temporary parking arrangement during scheduled repairs a major policy change? I believe it is. Judge Martinez looked down at the documents in front of her, then back up at Brenda. I have reviewed your HOA's management agreement, which was submitted by Mr. Chen. It explicitly gives the management company authority over temporary parking arrangements. Did you call an emergency board meeting to override their decision before having Mr. Garrison's vehicle booted? No, Your Honor. Did you give Mr. Garrison any notice that you believed he was in violation before having his car booted? No, Your Honor. Did you give him an opportunity to respond or move his vehicle? No, Your Honor. The judge set down her pen and looked directly at Brenda. Miss Zimmerman, it appears you acted unilaterally, without notice, without following your own procedures, and in direct contradiction of a decision made by the management company you hired. Is there any reason why I should not grant Mr. Garrison's motion? Brenda's face was bright red now. He has been a problem resident. He challenges board decisions and causes disruption at meetings. That is not relevant to whether his vehicle was legally parked. In fact, what you just said suggests you may have retaliated against him for exercising his rights as an owner. That is deeply troubling. I was enforcing the rules uniformly. Marcus stood up. Your Honor, if I may, we have evidence that other residents were also parking in guest parking during the same period, and none of their vehicles were booted. Only my client's vehicle was targeted. He handed a stack of photographs to the bailiff, who passed them to the judge. I had spent an evening walking around the complex taking pictures of all the other resident vehicles parked in guest spaces. I had even captured license plates and checked them against the resident directory to confirm they were owners, not guests. Judge Martinez reviewed the photographs carefully. These show 8 other vehicles parked in guest parking around the same time as Mr. Garrison's vehicle. Miss Zimmerman, were any of these other vehicles booted? No, Your Honor. Why not? I did not notice them. You did not notice 8 other vehicles, but you noticed Mr. Garrison's Tesla. Brenda had no answer. Judge Martinez turned to Gerald Peterson. Mr. Peterson, your company has a contract with this HOA. What kind of verification procedures do you have to ensure boot requests are legitimate? As I said, we rely on the HOA's representation. You do not think that is a problem? You are immobilizing people's vehicles based solely on the word of someone who calls you, with no independent verification. We require that the caller be a board member or property manager. How do you verify that? We ask for their name and position. So anyone could call you, claim to be a board member, and have a vehicle booted. Peterson looked uncomfortable. I suppose so, but that has never been an issue. It is an issue now. You have participated in what appears to be targeted harassment of Mr. Garrison. Your failure to implement any meaningful verification procedures makes you liable for the consequences. Judge Martinez turned back to her notes, spent a moment writing something, then looked up at all of us. Here is my ruling. The plaintiff's motion for injunctive relief is granted. Valley Boot Removal Services is ordered to immediately remove the boot from Mr. Garrison's vehicle at no cost to him. This is to be done within 2 hours of this hearing. If the boot is not removed within that time frame, the company will be subject to contempt sanctions, including fines of $500 per hour until compliance. Brenda started to speak, but the judge held up her hand. I am not finished. The HOA is ordered to cease all enforcement actions against Mr. Garrison related to his parking in guest spaces during the announced repair period. The daily fines that have been assessed are vacated and must be removed from his account. Additionally, the HOA is prohibited from taking any retaliatory action against Mr. Garrison for filing this lawsuit. If I receive evidence of retaliation, I will impose sanctions against the board members personally, not just the association. She looked at Gerald Peterson. Mr. Peterson, I strongly suggest your client review its business practices. The lack of verification procedures is unacceptable and exposes your company to significant liability. Finally, she turned to Brenda. Ms. Zimmerman, I suggest the HOA retain competent legal counsel immediately. Based on what I have seen today, Mr. Garrison has a very strong case for harassment, selective enforcement, and possibly breach of fiduciary duty. This is not going to go away just because you want it to. You acted improperly, and there will be consequences. She banged her gavel. The boot will be removed within 2 hours. This hearing is adjourned. We all stood as the judge left the bench. I felt a surge of relief and vindication. Marcus clapped me on the shoulder. That went extremely well. Judge Martinez sees exactly what happened here. Gerald Peterson approached us. I will have someone out there within the hour to remove the boot. Make sure you do, Marcus said. We will be documenting the time of removal. Brenda stormed out of the courtroom without speaking to anyone. I could hear her on her phone in the hallway, speaking in angry, hushed tones. Marcus and I went to a coffee shop near the courthouse to wait. Exactly 47 minutes after the hearing ended, I received a call from Valley Boot Removal Services, confirming the boot had been removed. Marcus and I drove to the complex together so he could witness and photograph the removal. My Tesla was free, with no visible damage to the wheel or body. I took my car for a drive, just enjoying the feeling of having it back. Then I returned to my unit and tried to decompress. The legal battle was far from over. The lawsuit would continue and discovery would be starting soon. Over the next 2 weeks, things got interesting. First, the HOA hired an attorney, a woman named Patricia Helms who specialized in community association law. She sent Marcus a settlement offer. The HOA would drop all claims against me, issue a written apology, and pay $5,000 to cover my expenses. In exchange, I would dismiss the lawsuit with prejudice. Marcus and I discussed it over the phone. What do you think? He asked. $5,000 does not even cover your fees, let alone compensate me for the harassment and stress. And it does nothing to prevent Brenda from doing this again to someone else. I agree. I think we should counteroffer. We want full attorney's fees, $10,000 in compensatory damages, a formal apology to be posted in the community newsletter and on the HOA website. Brenda's resignation from the board, and a policy change requiring the board to follow proper procedures before any enforcement action. Will they go for that? Probably not, but it is a starting point. Let me draft the counteroffer. Patricia rejected our counteroffer immediately. She claimed it was excessive and that Brenda had no intention of resigning. We moved forward with discovery. Discovery in civil litigation is the process where both sides exchange information and documents relevant to the case. We sent the HOA requests for production of documents, interrogatories, and requests for admission. We asked for all emails, text messages, and other communications related to parking enforcement for the past 2 years. We asked for all board meeting minutes and records of enforcement actions taken against residents. We asked for the HOA's policies and procedures for enforcement. What we received was explosive. The documents showed that over a 2-year period, the HOA had taken enforcement action against 17 different residents. Of those 17, 9 were related to parking violations. Of those 9 parking violations, 7 involved me. The other 2 residents had received warning notices only. I was the only resident who had ever been fined or had a vehicle booted. The emails were even more damning. We found multiple exchanges between Brenda and other board members where she explicitly discussed targeting me. In one email, she wrote, "Wade Garrison thinks he is better than everyone else. We need to make an example of him so other residents know not to challenge the board." In another email, sent just 2 days before my car was booted, Brenda wrote to the HOA treasurer, "I am tired of Wade's attitude. I am going to find a way to make him regret buying here." Marcus was ecstatic when he read these emails. "This is textbook harassment and retaliation." She put it in writing. This case just went from strong to slam dunk. We also discovered that Valley Boot Removal Services had booted vehicles at Riverside Meadows 43 times over the past 18 months. Of those 43 boots, 31 were later determined to be improper. Residents had either been authorized to park there, or the HOA had made mistakes in identifying violations. Yet the boot company had never removed a boot without payment, except when forced to by court order or threat of lawsuit. We sent additional discovery requests to Valley Boot Removal Services. Their attorney resisted, claiming much of what we requested was proprietary business information. Marcus filed a motion to compel, and the judge ordered them to produce the documents. Those documents revealed that Valley Boot Removal Services made over $400,000 per year from HOA contracts in the Phoenix metro area. They had been sued 17 times in the past 5 years for improper boots, settling most cases for small amounts to avoid going to trial. They had never implemented any verification procedures despite repeatedly promising courts they would do so. With all this evidence in hand, Marcus prepared for depositions. A deposition is where attorneys ask witnesses questions under oath, with a court reporter recording everything. It is one of the most important parts of discovery because people have to answer questions directly and cannot hide behind lawyers. We scheduled Brenda's deposition for a Wednesday morning at Marcus's office. She arrived with Patricia Helms, looking nervous. The court reporter set up in the conference room, and we all took our seats. Marcus began with basic background questions, establishing Brenda's role on the board and her responsibilities. Then he moved into the specific incident. "Miss Zimmerman, when did you first become aware that Mr. Garrison had parked in guest parking on the morning in question?" Brenda looked at Patricia, who nodded. "I saw him park there around 8 in the morning." "What did you do when you saw him park there?" I made a note of it. "Did you check to see if he had permission to park there?" "No." Why not? Because guest parking is for guests. Were you aware that the property management company had sent an email to all residents authorizing them to park in guest parking during the repairs? I learned about that email later. When did you learn about it? I do not remember exactly. Marcus slid a document across the table. This is a copy of the email which was sent 3 days before the incident. You are listed as one of the recipients. Did you read it? Brenda looked at the email, her face tightening. I may have skimmed it. So you were aware that residents had been given permission to use guest parking. I did not think that permission was valid without board approval. Did you call an emergency board meeting to discuss overriding the management company's decision? No. Did you contact any other board members before calling the boot company? No. So you acted unilaterally. I used my judgment as vice president. Does the HOA's governing documents give you authority to act unilaterally in enforcement matters? Brenda hesitated. I believe so. Marcus slid another document across the table. This is the HOA bylaws. Please read the highlighted section. Brenda read it silently. The section stated that enforcement actions required approval from at least 2 board members, except in emergency situations requiring immediate action. Was Mr. Garrison's vehicle creating an emergency situation? No. So you violated the bylaws by acting alone. Patricia leaned forward. You do not have to answer that. It calls for a legal conclusion. I will rephrase, Marcus said. Did you get approval from another board member before calling the boot company? No. Did you consider this an emergency situation? No. Marcus continued questioning her for 2 more hours, methodically going through every decision she made. She admitted she had not given me notice, had not checked if I had permission, had not consulted other board members, and had not followed the HOA's own procedures. She also admitted that she had not booted any other vehicles that were parked in guest parking that same day. Then Marcus pulled out the damning emails. Miss Zimmerman, did you write this email to the HOA treasurer that says, I am tired of Wade's attitude? I am going to find a way to make him regret buying here. Brenda's face went pale. She looked at Patricia, who looked equally concerned. I may have written that in frustration. In frustration about what? Wade had been disruptive at board meetings. Disruptive how? He questioned our decisions. Is questioning board decisions allowed under the HOA's rules? Owners can speak at meetings. So Mr. Garrison was exercising his right to participate in meetings, and you decided to make him regret buying there. I did not mean it that way. How did you mean it? I was just venting. 2 days after sending this email, you had his car booted. Was that a coincidence? Yes. You expect us to believe that you wrote an email saying you were going to find a way to make Mr. Garrison regret buying here. And then 2 days later, you just happened to have his car booted even though he had permission to park there. And those 2 things are completely unrelated. Brenda did not answer. Miss Zimmerman, you need to answer the question. It was a coincidence. Marcus let the silence hang for a moment. We will let a jury decide if they believe that. The deposition continued for another hour, with Marcus asking about other enforcement actions and why I had been targeted so frequently. By the end, Brenda looked exhausted and defeated. Patricia had intervened numerous times to instruct her not to answer, but the damage was done. We also deposed the president of Valley Boot Removal Services, a man named Donald Hayes. He admitted that his company had no verification procedures, that they relied entirely on the word of whoever called them, and that they knew many of their boots were improper, but did not care because they got paid either way. Mr. Hayes, you have been sued 17 times in 5 years for improper boots. After the first lawsuit, did you implement any changes to your procedures? We reminded our employees to ask for the caller's name and title. That is it. Yes. You did not think it would be prudent to verify that the vehicle was actually parked illegally before immobilizing it. That is the HOA's responsibility, not ours. You are the one physically immobilizing the vehicle. You do not think you have any responsibility to make sure it is done legally. We are acting on behalf of the HOA. Even when the HOA representative is acting without authority, Donald shifted in his seat. We assume they have authority. Even though you have been sued multiple times for making that assumption, we have a business to run. We cannot spend hours verifying every boot request. How long would it take to ask for written confirmation that a vehicle is in violation? I do not know. An email takes 30 seconds. Could you require written confirmation before booting a vehicle? I suppose we could. But you do not. No, because you make more money booting as many vehicles as possible, regardless of whether it is legal. Patricia's equivalent from Valley Boot Removal Services objected. That is argumentative. I will rephrase. How much does your company make per boot on average? About $250. How many boots do you do per month? Around 100. So your company makes $25,000 per month from boots, approximately $300,000 per year. Yes. And about 70% of those boots are later disputed by vehicle owners. I do not have that number in front of me. Marcus slid a document across the table. This is your company's internal report on disputed boots. According to this, 72% of all boots placed in the past 2 years were disputed. Is that accurate? Donald looked at the document reluctantly. If that is what the report says. So your company is knowingly placing boots on vehicles where the owner disputes the validity more than 70% of the time, and you have no procedures to prevent improper boots. We cannot control whether people dispute them. But you could verify they are legitimate before placing them. We rely on the HOA. The deposition made clear that Valley Boot Removal Services had a business model built on volume, not accuracy. They wanted to boot as many vehicles as possible because every boot meant revenue. They did not care if the boots were proper because even disputed boots usually resulted in payment. Most people did not have the time, money, or energy to fight back like I was doing. With both depositions complete, Marcus scheduled a mediation. In Arizona, courts often require parties to attempt mediation before trial. A neutral mediator helps both sides negotiate a settlement. If mediation fails, the case goes to trial. The mediation was scheduled for a Thursday afternoon at a mediator's office in downtown Phoenix. The mediator was a retired judge named Harold Campbell, who had a reputation for being fair but tough. He did not let people waste time with posturing. We arrived early. Marcus and I sat in one conference room while the defendants and their attorneys sat in another. Judge Campbell went back and forth between the rooms, hearing each side's position and trying to find common ground. He started with us. Mr. Garrison, tell me what you want to get out of this case. I want compensation for what they did to me. I want my attorney's fees paid. I want Brenda removed from the board so she cannot do this to anyone else. And I want Valley Boot Removal Services to implement real verification procedures so they stop illegally booting people's cars. What about money? What number would make you happy? I looked at Marcus. We had discussed this. $50,000 from the HOA, $25,000 from the boot company, plus all attorney's fees and costs. Judge Campbell nodded and went to the other room. He came back 15 minutes later. The HOA is willing to pay $20,000 plus attorney's fees. Brenda will not resign, but she will agree not to take any enforcement action against you personally for the next 5 years. Valley Boot Removal Services is offering $5,000 plus your out-of-pocket costs for the Ubers, but no attorney's fees. That is not even close, I said. The evidence is overwhelming. We have emails showing Brenda targeted me out of retaliation. We have proof that the boot was illegal. We have proof that the boot company has been doing this to dozens of people. I agree your case is strong, but trials are expensive and unpredictable. A settlement gives you certainty. I want justice, not just money. Brenda needs to face consequences for what she did. Judge Campbell went back to the other room. This went on for hours, with offers and counteroffers going back and forth. By 6 in the evening, we were at an impasse. The HOA had come up to $35,000 plus fees, with Brenda agreeing to take a 1-year leave of absence from the board. Valley Boot Removal Services was stuck at $10,000. Marcus and I talked privately. If we go to trial, we are likely to win significantly more, he said. But it will take another 6 months and cost you another $20,000 in attorney's fees. Even if we win fees at trial, collection can be difficult. I want to go to trial. This is not just about me anymore. It is about holding them accountable. Are you sure? I am sure. We told Judge Campbell we were rejecting the settlement offers. He brought everyone together in one room for a final discussion. We are here because Mr. Garrison believes he was wronged and wants accountability, Judge Campbell said. The defendants believe they acted within their authority and that the damages are minimal. Neither side is willing to move enough to reach an agreement. This case is going to trial. He looked at Brenda. Miss Zimmerman, I have been doing this for 30 years. I have read the emails. I have read the depositions. You are going to lose at trial, and you are going to lose badly. The jury is going to see that you retaliated against Mr. Garrison for exercising his rights as an owner. They are going to award him substantial damages, and the HOA is going to be on the hook for all of it. You should settle this case. Brenda crossed her arms. We are not going to be bullied into paying him money he does not deserve. Judge Campbell turned to Donald Hayes. Mr. Hayes, your company has terrible business practices. You boot first and ask questions never. That works until you run into someone willing to fight back. Mr. Garrison is that person. If this goes to trial, the jury is going to punish you for your practices. You should settle. Donald looked at his attorney, who whispered something to him. We will go to $10,000, but that is our final offer. Not enough, I said. The mediation ended without a settlement. We scheduled a trial date for 4 months later. Over those 4 months, Marcus prepared extensively. We identified witnesses, prepared exhibits, and drafted jury instructions. We also filed a motion for partial summary judgment, arguing that certain facts were undisputed and the judge should rule in our favor on liability, leaving only damages for the jury to decide. The motion for summary judgment hearing took place 6 weeks before trial. Marcus argued that the evidence was overwhelming. I had permission to park in guest parking. Brenda had no authority to override that permission. The boot was illegal, and Brenda's own emails proved she acted out of retaliation. Patricia Helms argued that there were disputed facts about whether the management company's email was valid and whether Brenda had reasonably interpreted the HOA's governing documents. Judge Martinez was not persuaded by Patricia's arguments. She granted our motion for partial summary judgment, ruling that the boot was illegal as a matter of law. The only question for the jury would be how much in damages to award. This was a huge victory. It meant we did not have to prove liability at trial. The defendants were already found to have violated my rights. The jury just had to decide how much they should pay. Patricia filed an emergency motion for reconsideration, but Judge Martinez denied it. The trial would proceed on damages only. As the trial date approached, the settlement offers increased. The HOA went to $50,000 plus fees. Valley boot removal services went to $20,000. But I held firm. We had come this far, and I wanted a jury to send a message. The trial began on a Monday morning in late September. The courthouse was busy with multiple trials happening simultaneously. Our trial was assigned to Judge Martinez, which was good news for us since she already understood the case. Jury selection took most of the morning. We needed to find 12 jurors and 2 alternates who could be fair and impartial. Marcus asked potential jurors about their experiences with HOAs, parking enforcement, and whether they could award significant damages if warranted. By lunchtime, we had our jury, 7 women and 5 men, ranging in age from mid-20s to late 60s. Opening statements began after lunch. Marcus went first. He told the jury about my background as a physician, my ownership of 3 units, and how I had been targeted by Brenda after questioning the board's financial decisions. He described the morning I came home from a 16-hour shift and parked legally in guest parking, only to have my car booted by Brenda in an act of retaliation. He showed the jury the emails where Brenda said she would make me regret buying there. This case is about abuse of power, Marcus told the jury. Miss Zimmerman used her position on the HOA board to punish Mr. Garrison for exercising his rights. She violated the HOA's own rules. She acted without authority, and she did it intentionally to hurt him. The question is not whether she did it. The judge has already ruled that she did. The question is how much she should pay for what she did. Patricia Helms gave the opening for the HOA. She tried to paint Brenda as a dedicated volunteer who made a mistake in judgment but had no bad intentions. She argued that any damages should be minimal since I only lost use of my car for a few days. The attorney for Valley Boot Removal Services, a man named Thomas Wright, argued that his client was just following its contract with the HOA and should not be held responsible for Brenda's actions. The evidence phase of the trial lasted 2 days. Marcus called me as the first witness. I testified about coming home exhausted from my shift, parking legally in guest parking, and discovering the boot. I explained the stress and anger I felt at being targeted. I described having to take Ubers to work and the disruption to my life. Patricia cross-examined me, trying to suggest I was overreacting to a minor inconvenience. Dr. Garrison, you were only without your car for a few days, correct? Yes, but it was not just about the car. It was about being targeted and harassed by someone who was supposed to be serving the community. You have filed other complaints about Miss Zimmerman before, have you not? Yes, because she has repeatedly targeted me. Or perhaps you are overly sensitive to normal HOA enforcement. There was nothing normal about this. I had permission to park there, and she knew it. Marcus called Lisa from the property management company. She testified about the email authorizing residents to use guest parking and confirmed that Brenda had no authority to override that decision without a board vote. We also called 2 other residents who testified that they had parked in guest parking during the same period and were not booted. One of them, a retired teacher named Margaret, said she had asked Brenda directly about the guest parking issue, and Brenda had told her it was fine to park there. This contradicted Brenda's claim that she believed no residents were allowed in guest parking. The most powerful evidence was the emails. Marcus displayed them on a large screen for the jury to read. When Brenda's email saying, "I am going to find a way to make him regret buying here," appeared on the screen, I saw several jurors react with surprise and disapproval. On day 3, Brenda testified. Patricia had clearly prepared her extensively, but she still came across as defensive and evasive. When Marcus cross-examined her, she could not explain why she had not booted other residents, why she had not followed proper procedures, or why she had sent the email about making me regret my purchase. Miss Zimmerman, you wrote that you were going to find a way to make Mr. Garrison regret buying at Riverside Meadows. What did you mean by that? I was frustrated. He had been difficult at board meetings. Difficult how? He questioned our decisions. Is that not his right as an owner? Yes, but he was disrespectful. Disrespectful how? Give me a specific example. Brenda struggled to answer. He just had a condescending tone. So because you did not like his tone, you decided to retaliate against him by having his car booted. No, that is not what happened. Then explain what happened. You sent an email saying you would make him regret buying there. 2 days later, you had his car booted even though he had permission to park there. What is the explanation? It was a coincidence. A coincidence. Yes. Marcus let that answer hang in the air for a moment. Several jurors looked skeptical. Donald Hayes from Valley Boot Removal Services testified next. Thomas Wright tried to portray him as a businessman just following a contract, but Marcus tore that apart on cross-examination. Mr. Hayes, you have been sued 17 times in 5 years for improper boots. After the first lawsuit, did you change your procedures? We made improvements. What improvements? We trained employees better. But you still do not verify whether a vehicle is actually parked illegally before booting it. We trust the HOA. Even after being sued 17 times, those were all settled, because you knew you would lose at trial. That is not why we settled. Then why did you settle? To avoid the expense of litigation. So it is cheaper to settle improper boot cases than to implement verification procedures. Donald did not answer. Let me ask it differently. How much have you paid out in settlements over the past 5 years? I do not have that number. Marcus pulled out a document. Your financial records show you have paid approximately $200,000 in settlements. Is that accurate? If that is what the records show. And how much would it cost to implement a verification system where you require written confirmation before booting a vehicle? I do not know. Would it cost $200,000? No. Would it cost $100,000? No. So you could implement a system that would prevent improper boots for less than you have already paid out in settlements, but you choose not to do that. Our current system works for us. It works for you because you get paid either way, regardless of whether the boot is proper. Is that fair to say? We provide a service. A service that you admit is wrong more than 70% of the time. Thomas Wright objected, but the point had been made. Closing arguments took place on day 4. Marcus went first, summarizing the evidence and asking the jury to award substantial damages. Members of the jury, you have heard the evidence. Miss Zimmerman abused her power. She retaliated against Dr. Garrison for exercising his rights as an owner. She violated the HOA's rules. She acted without authority, and she did it intentionally. The emails prove it. Valley Boot Removal Services enabled her abuse. They have a business model based on booting first and asking questions never. They have been sued 17 times and still refuse to implement basic verification procedures. They do not care if boots are improper because they get paid either way. Dr. Garrison is asking for compensation for his damages. He paid for Ubers. He paid attorney's fees. He suffered stress and humiliation. But more than that, he is asking you to send a message that people cannot abuse power without consequences, a message that companies cannot profit from illegal conduct, a message that when someone stands up for their rights, the law will protect them. We are asking for $75,000 in compensatory damages, $25,000 from the HOA for the harassment, retaliation, and stress they caused, $50,000 from Valley Boot Removal Services for their reckless business practices. We are also asking for punitive damages to punish the defendants and deter future misconduct. The exact amount is up to you, but it should be significant enough to make them change their behavior. Finally, we are asking for attorney's fees and costs. Dr. Garrison should not have to pay out of his own pocket to defend his rights. The defendants caused this problem. They should pay to fix it. Thank you for your service. We trust you will do the right thing. Patricia Helms gave the closing for the HOA. She tried to minimize Brenda's conduct and suggested that the appropriate damages were no more than a few $1,000s. Her argument fell flat after the evidence the jury had seen. Thomas Wright argued that Valley Boot Removal Services should not be held responsible for Brenda's actions, and that any damages against his client should be minimal. He also fell short. The judge instructed the jury on the law and sent them to deliberate at 3 in the afternoon. Marcus and I waited in a small conference room down the hall. Waiting for a jury verdict is one of the most stressful experiences imaginable. You have no control, no insight into their thinking, and no idea how long it will take. At 6 in the evening, we got word that the jury had reached a verdict. We returned to the courtroom. My heart pounded as the jury filed in. None of them looked at me, which I had heard could be a bad sign or no sign at all. Judge Martinez addressed the jury foreman, a man in his 50s who worked as an accountant. "Has the jury reached a verdict?" "We have, Your Honor." "Please hand the verdict form to the bailiff." The bailiff took the form to the judge, who reviewed it silently. Her expression did not change. Then she handed it back to the bailiff, who returned it to the foreman. "Will the parties please rise?" We all stood. "Mr. Foreman, please read the verdict." The foreman cleared his throat. "We, the jury, find in favor of the plaintiff, Wade Garrison, and against the defendants on all counts. We award compensatory damages as follows: $30,000 against the Riverside Meadows Homeowners Association and $60,000 against Valley Boot Removal Services, for a total of $90,000 in compensatory damages. I felt a wave of relief wash over me. But the foreman was not finished. We also award punitive damages as follows: $50,000 against the Riverside Meadows Homeowners Association and $150,000 against Valley Boot Removal Services, for a total of $200,000 in punitive damages. The total was $290,000, plus attorney's fees and costs. It was a complete victory. Judge Martinez thanked the jury and dismissed them. After they left, she turned to the parties. "I will hold a hearing on attorney's fees in 2 weeks. Please submit your fee petitions by next Friday. This court is adjourned." Outside the courtroom, Marcus was grinning. "That was one of the best verdicts I have seen. The jury sent a clear message. What happens now? We file a petition for attorney's fees. My fees are around $45,000 so far. We will ask for that plus costs, which are probably another $5,000. If the judge awards the full amount, you will walk away with about $340,000 total. Will they pay? They have to. If they do not, we can garnish bank accounts and put liens on property. It might take some time, but you will get paid." 2 weeks later, Judge Martinez held the fee hearing. She reviewed Marcus's billing records and found them reasonable. She awarded the full $45,000 in attorney's fees plus $5,200 in costs. The total judgment was $340,200. Patricia Helms filed a notice of appeal on behalf of the HOA, but Marcus was not concerned. Appeals are expensive and rarely successful. They are just posturing. I expect they will settle the appeal for the judgment amount rather than spend another $100,000 on appellate attorneys. He was right. 2 months later, the HOA's new attorney, not Patricia, reached out to Marcus. The HOA wanted to settle the appeal. They would pay the full judgment amount in exchange for dropping the appeal and a confidential settlement agreement. I agreed on one condition. Brenda had to resign from the board. The HOA agreed. Brenda resigned the following week, citing personal reasons. Valley Boot Removal Services also settled, paying their portion of the judgment plus agreeing to implement verification procedures for all future boots. Marcus negotiated to include that requirement in the settlement agreement so it would be enforceable. The checks arrived in early December. After paying Marcus and covering my costs, I netted about $270,000. But more important than the money was the principle. I had stood up to abuse of power and won. The HOA elected a new board, and the culture at Riverside Meadows improved dramatically. The new board hired a different management company and implemented transparent procedures for enforcement actions. Several other residents thanked me privately for taking on Brenda. Apparently, I was not the only one she had harassed, just the only one willing to fight back. As for Valley Boot Removal Services, they did implement verification procedures as required by the settlement. According to news reports I saw later, their improper boot rate dropped from 70% to under 10%. They were sued less frequently, and their reputation improved. I kept my 3 units at Riverside Meadows. My tenants are great, and the complex is well managed now. I still serve on the finance committee, asking tough questions and holding the board accountable. But now they welcome the input instead of retaliating against it. Looking back, I am glad I did not settle early. The case was never really about the $250 boot fee. It was about refusing to be bullied, standing up for what is right, and ensuring that people in positions of power face consequences when they abuse that power. Too many people accept mistreatment because fighting back is hard, expensive, and time-consuming. But sometimes fighting back is the only way to create change. The best part came 6 months after the trial. I received a letter from a resident at a different HOA in Phoenix. She had read about my case in the local news and was dealing with similar harassment from her board. She asked if I could recommend an attorney. I put her in touch with Marcus, who took her case. She won a similar verdict. That letter made me realize that my case had impact beyond just my situation. It set a precedent and gave other people courage to stand up for themselves. That, more than any amount of money, made the entire ordeal worthwhile. I still drive my Tesla, still work long shifts at the hospital, and still come home to park in my assigned spot in the now repaired parking structure. Every time I pull in, I think about that morning when I found the boot on my car. I think about how angry and helpless I felt in that moment, and I think about how I turned that anger into action. Brenda moved to a different city about a year after the trial. I heard through the community grapevine that she joined the HOA board at her new complex. I hope she learned something from our legal battle, but I somehow doubt it. Some people never learn. The difference is that now if she tries the same tactics, her victims will know they can fight back and win. The units I own have appreciated in value significantly since I bought them. The complex is thriving under better management. My tenants are happy. And I have the satisfaction of knowing that I stood up not just for myself, but for every homeowner who has been bullied by someone on a power trip. Justice is not always swift, and it is not always cheap, but it is always worth fighting for.